Three basic categories of takings that I wanted to touch on. Physical takings, of course, is what we're all used to seeing, where the government or another entity with the power of eminent domain says we're taking, the front 10 feet of your property to widen the road, or put in a sidewalk or something along those lines. Then you have a regulatory taking, which is an exercise of the police power, usually through zoning. Where there isn't an actual physical loss of property, but your ability to make use of your property is being limited. And then what we call a pro tanto taking, or substantial interference taking, which has to do with a fundamental property interest that's tied up in the bundle of sticks that you own as the property owner that's being taken away from you. And the classic example is from a Supreme Court case called OTR, which I think was up in North Columbus or Worthington, and it was a situation where you had an at-grade railroad track in the before the taking, and then what they were doing was putting a railroad overpass for the cars to go over the railroad, and they had to build up an overpass for that, obviously, and as a result of that, this particular property that was abutting on the railroad, where it used to have at-grade access along its frontage to the roadway, now had a sheer retaining wall that went up to the height of 30 feet or so, and could no longer develop that right of access. And because the right of access to an abutting roadway is considered a fundamental incident of property ownership, even though there wasn't a physical taking, the Supreme Court in that case said that is a substantial interference taking, or pro tanto, meaning to that extent. So to the extent that right was taken, there was a taking to that extent. But I do want to talk a little bit more about regulatory takings, because I think this is sort of a nuanced area that people don't understand all that well. Like I said, it has to do with an exercise of the police power, usually through zoning. And there are two kinds. You have a total regulatory taking, or you can have a partial regulatory taking, which is the same, by the way, as in a physical takings case. And there are two U.S. Supreme Court cases that apply, and it depends on which one you're dealing with. So if you have a total take, it's this Lucas versus South Carolina Coastal Council case. In such a circumstance, the regulation has deprived the property of all economic value. It can't be used for anything productive. And then you have the Penn Central case, which is for partial takings, and that's a standard. They call it an ad hoc balancing test, which basically just means it's fact specific based on the case. And there are three factors that are weighed: the nature of the governmental regulation, the economic impact of the regulation on the claimant and their property, and the extent to which the regulation interferes with what we call distinct investment-backed expectations. If that all seems about as clear as mud to you, you're not alone. So I've got a couple more slides on here which attempt to clarify it a little more, but it's sort of a subjective area of inquiry. So the first one, the nature of the governmental regulation. What you have there is the court balancing, on the one hand, the liberty interest of the property owner against the government's interest in protecting the public. And the factors that they look at are, degree of harm created by the prohibited activity, the social value and location of the activity, the ease with which harm could be prevented, and the extent to which the regulation is retroactive, as well as whether the regulation targets a particular individual. And then you have the economic impact factor. Here the court compares the value that's been taken with the value that remains after the regulation. And in doing this analysis, the court's supposed to look at the property owner's basis, I guess, to borrow an accounting term, in the property. So, what did they pay for it? What improvements have they made over time? What kinds of cost benefits have they received as a virtue of ownership over time? And then the final factor is the extent to which the regulation interferes with distinct investment-backed expectations. Basically here, what the court's looking at is, did you know this was coming? Was it reasonable for you to rely on the existing regulatory framework at the time that you purchased the property? And if it was foreseeable, that's going to weigh strongly against you as a regulatory taking plaintiff. This slide talks about the substantial interference takings, which I talked about a little bit ago. Here you have that citation for the OTR decision I referenced. The standard there is, does the governmental action substantially or unreasonably interfere with the property right?